Good morning. We hope you and your families and friends have kept well throughout this lockdown. Thank you very much indeed for joining us, the Property Dispute Resolution team at Landlords, for our webinar on the impact of the coronavirus on payment of rent and looking ahead to the June quarter date. For those I haven't met yet, my name is Jane Senior, a partner in the Property Dispute Resolution team at Landlords. And I'm delighted to introduce my colleagues who are presenting today: Vicky Canker, also a partner in our team, and Ellie Crofts, a senior associate in our team. Also joining us today, just for your information really, is Lauren Smith, who is a specialist in residential tenancies, and if you have any queries along those lines, Lauren or Lydia Elvin would be very ready to assist with those. We also, in property dispute resolution, as well as landlord and tenant issues, we deal with things such as rights of way, boundaries, rights to light, party walls, overage, anything really, any issue relating to property or land. We can provide advice and hopefully support whatever situation arises. And also, just to mention, we're really pleased to have some colleagues from our commercial property team on the webinar today. So, what specifically will we be covering this morning? Well, we have an agenda here. So first of all, to comment on what we have seen in the March quarter, then measures already introduced, including points on the Coronavirus Act and CRA, which used to be known as distraint. Then we'll look at future measures, predictions for the June quarter, a bit of advice for tenants, a bit of advice for landlords, and then we'll conclude and, as I said, invite your comments. So Ellie is going to start us off with comments on what we have seen to date in the March quarter. So Ellie, over to you.
Thank you, Jane. Good morning, everybody. I think the Coronavirus Act caught us all by surprise. I don't think many people thought that the way we work and the way businesses will operate will change quite this much or quite so quickly. Businesses were forced to close with little notice, and very few will have had contingency plans to deal with a lockdown on the scale imposed by the government. After employee costs, rent on business premises can be one of the highest outgoings for a commercial tenant. When numerous businesses were forced to close on the 23rd of March, just days before the March quarter day, many didn't know what they were going to do about paying the rent. Some immediately contacted their landlords, others just didn't pay. Statistics show that approximately 2/3 of the UK commercial rental bill wasn't paid in full on the March quarter day, with around half of retail tenants failing to pay up either in full or in part. Most tenants couldn't afford to pay, and others wanted to preserve as much cash in their businesses as possible. One tenant that I dealt with paid 2 weeks worth of the quarter's rent and then issued a letter to all their landlords advising that it was going to pay monthly in arrears. My landlord client wasn't particularly happy about this unilateral decision by the tenant, but it did accept that in this case the tenant wasn't seeking a rent reduction, just an amendment to the payment terms, which is, as this particular tenant was still trading, it meant that it was still able to pay the full rent. Ultimately, the landlord in this case wasn't losing any money, but it was just receiving it a little bit later than it might like. And this is what we've typically found to be the case following the March quarter, as a lot of tenants could still afford to pay their rent as they were trading right up to lockdown. Whilst many tenants initially refused to pay the March quarter, many did ultimately contact their landlords to agree payment plans or amendments to payment terms. And the issues that were generally arising where tenants weren't getting in touch with their landlords, they were sticking their heads in the sand. And we received quite a few calls from landlords seeking assistance in persuading tenants to either pay their rent or come to some kind of an agreement. And we have been largely successful with that. So the next thing I'm going to talk about is looking at the legislative measures that have already been introduced in relation to dealing with issues over rent during the coronavirus pandemic. The Coronavirus Act 2020 introduced various measures protecting tenants, and the main section that we're going to focus on this morning is section 82, which introduced three principal measures to deal with the issue. The first of those is a prohibition on enforcing rights of re-entry for rent arrears, a provision preventing a landlord from enforcing a possession order until the end of the relevant period, and I'll explain what that is in a minute, and a provision preventing a landlord from using non-payment of rent as a ground for refusing a new lease under the 1954 Act. So what does this all mean? Firstly, I mentioned the relevant period wherein these prohibitions are taking place. And this is described by the Act as the period between the 25th of March 2020, which was the day the Act came into force, and the 30th of June 2020. This end date of the 30th of June is capable of being extended by statutory instrument. The first restriction, which is the removal of the landlord's right to forfeit a lease for non-payment of rent, I think is pretty well known by now. Most people are aware of this, this restriction on landlords. But one thing it is important to bear in mind is that rent doesn't just mean annual rent in these circumstances. It also includes any other sums payable under the lease, including service charges and insurance rent. So it may be that your tenant isn't in arrears of actual rent, but they've failed to pay the service charge. Unfortunately, you're not allowed to forfeit for that reason as well. But having said that, the restriction only relates to where there are arrears of rent or sums reserved as rent. A landlord can still forfeit for any other breach in the usual way. For example, if a tenant has been unlawfully subletting, it's permitted to forfeit, subject to the usual service of Section 146 notices. What the Act is really seeking to prevent here is landlords taking peaceable re-entry without any warning due to non-payment of rent, because that is something that tenants obviously are struggling with. It isn't all bad news for landlords though. Section 82(2) of the Act provides that a landlord can't waive its right to forfeit for non-payment of rent except by express written waiver. Now, ordinarily, if a landlord is going to have a right to forfeit for a breach, anything that accepts the lease as ongoing, such as demanding rent or giving consent to sublet, means that the landlord would waive its right and lose its right to forfeit for that breach. But the Coronavirus Act is providing a temporary get out, and this means that landlords can continue to serve rent demands, continue to serve service charge demands on their tenants without waiving that right to forfeit when the restrictions are lifted. So looking at the other two provisions under the Coronavirus Act, there's the restriction on the enforcement of possession orders. Again, this only relates to orders that have been obtained for non-payment of rent. So if a landlord has already obtained a possession order for a different breach, that's capable of being enforced, subject to finding suitable enforcement agents. And the final principal provision of Section 82 is the landlord cannot use non-payment of rent as a reason to refuse a new tenancy under the 1954 Act. You'll all be aware that persistent non-payment of rent is one of the grounds, I think it's ground B, under which a landlord can refuse to grant a new lease to a protected tenant. This is not allowed now, at least until the 30th of June, maybe longer depending on whether the relevant period gets extended. I'm briefly going to mention another form of enforcement that has been affected by the coronavirus pandemic and legislative changes, which is commercial rent arrears recovery. Now, as Jane mentioned, this is used to be known as distraint. It's the process which allows a landlord to seize a tenant's goods to cover unpaid rent. CRA was introduced in 2014 as an alternative to distraint, and it wasn't particularly popular when it was introduced, as landlords had to start giving notice to their tenants of their intention to seize goods, where previously no notice had been required. There's also some additional restrictions on CRA. It can't be exercised by the landlord personally. It can only be exercised by an authorised enforcement agent. The costs that are recoverable at each stage of the process are quite limited. They are limited by statute. CRA is also only available to landlords of commercial premises, not residential premises and can only be used to claim arrears of pure rent, not any other amounts, such as service charges or insurance rent. And there also must be a written tenancy in place. Premises occupied under a licence or an oral tenancy are exempt from CRA. Nonetheless, I think despite its shortcomings, it can be an efficient and cost-effective method for landlords to recover rent. However, the government has introduced, and I have to read this, the Taking Control of Goods and Certification of Enforcement Agents Amendment Coronavirus Regulations 2020. They were introduced on the 25th of April earlier this year, and they have slightly changed the CRA regime. The principal change is that where a notice of enforcement is given by a landlord to a tenant after the 25th of April, after the regulations came in, CRA can only be exercised where there are at least 90 days of rent outstanding. And that's quite a significant increase on the previous 7 days outstanding rent that was required. If tenants haven't paid the March quarter, then I think that calculates as 91 days. So it may still be something that can be used by landlords. The regulations also extend the current time limits for exercising CRA where a notice has already been served prior to the regulations coming into force. Under the old rules, a landlord had 12 months to exercise CRA from the date that was given in the notice of enforcement, and that has been extended so that if the expiry of that 12-month notice falls after the 26th of March and before the lockdown provisions are lifted, then the landlord has a further 12 months to exercise CRA. So I think the big question is it still worthwhile to exercise CRA with these new regulations? I think it's still an option for landlords whose tenants have missed one or more quarters rent and whose premises are still accessible. Obviously, a lot of properties are closed at the moment. Particularly retail premises, they may be opening on the 15th of June. That's the current advice from the government. But what we've got to bear in mind is landlords may find it difficult to find an enforcement agent who is actually prepared to exercise CRA at the moment. You've got to be able to get into the property, but also find an enforcement agent who is willing to take on these jobs during the current pandemic. The other thing that landlords, I think, need to take into account is they need to consider a commercial view. Will exercising CRA against their tenants actually jeopardise their tenants' survival and therefore affect their future rental income? So I'm going to pass over to Vicky now, who's going to look at some of the proposed measures in this area.
Thanks, Ellie. So one of the methods that up until now we've had some success with in terms of recovering rent has been by the use of serving statutory demands on tenants as a precursor to winding up. But the government has now published its Corporate Insolvency and Governance Bill, which aims to support struggling businesses by amending insolvency and company law. The second reading was yesterday. I haven't been able to get much of an update because all of the press coverage has focused on Alok Sharma potentially having coronavirus whilst he was dealing with the reading. And so I haven't been able to see what's actually happened with it. But once it's passed, it will still need to go up to the Lords. The bill is particularly relevant to landlords seeking to enforce rent obligations because it proposes that where a statutory demand has been served between the 1st of March and either the 30th of June this year or 1 month after the bill coming into force, which is now the most likely, whichever is later, a creditor cannot present a winding up petition if the company does not satisfy the demand, i.e. the statutory demand will essentially be void. During that same period, no winding up petitions can be presented on other insolvency grounds unless a creditor has reasonable grounds for believing that either coronavirus has not had a financial effect on the company or the facts would have arisen even if coronavirus had not had that financial effect. It remains to be seen if the provisions will be extended even further beyond the current timeframes. And essentially how it will work is that petitions, the court can't stop people physically presenting winding up petitions, but they won't be permitted to be advertised until the first hearing where a judge has determined that it isn't due to coronavirus. But the bill isn't yet law, and given that it's still got to go up to the Lords, and I think the rumoured date for that is the 9th of June, so next week sometime, and who knows how long after that it will take to actually become law, it does technically mean that at the moment, in theory, you could still potentially seek to serve a statutory demand. That said, the bill does provide that if any petition is presented or a winding up order is made before commencement of the bill, it can have retrospective effect, so it could be set aside thereafter. And there is also within the bill the introduction of the ability to apply for a moratorium for 20 business days, which can be extended to prevent action being taken. There was a case heard in April 2020, the Shorts Garden case, where the court considered an application for an injunction to restrain the presentation of a winding up petition on the basis of COVID-19 and the government guidance in respect of the proposed bill. And the court in that case said they simply couldn't make a decision based on potential future law until it did become law. They couldn't act upon it, and therefore the injunction to prevent the winding up was refused, albeit there were indications in that case that the judge was particularly keen not to refuse it on the basis that it was evidence that coronavirus wasn't actually the cause of the business failure. It was already in a lot of difficulty prior to that. So that's what we know is imminently about to come in. In terms of various ideas mooted and predictions in respect of the June quarter, I expect probably that the provisions of the Coronavirus Act, which Ellie has been talking about, are likely to be extended, in particular the suspension of the ability to forfeit for the time being. I think there's also going to be a big rise in the use of creditors' voluntary arrangements as a way of avoiding insolvency. I think yesterday, perhaps, Travelodge has announced a formal restructuring plan, and it's going to enter into a company voluntary arrangement under which landlords would only receive 62% of the rent until the end of next year. I suspect we're going to see the use of a lot more of that coming up. There have been some talks about kind of like furlough schemes for commercial properties. A popular idea amongst some of the big hospitality restaurant chains, including Prezzo and Nando's, has been the idea of a rent abatement scheme, which would essentially be a national rent holiday, or alternatively to make rent turnover related until sales figures recover to pre-COVID levels. I think that's probably unlikely, and I'm sure would be extremely unpopular because it doesn't offer any help whatsoever for landlords. Perhaps a better suggestion, or slightly more palatable, is the furloughed space grant scheme, which would require the government to pay some of the rent. So tenants would contribute some rent, landlords would effectively contribute a portion of the rent by agreeing a rent reduction in part, and the government would make up the balance. And this has been quite successfully introduced in Denmark. It's got to be more attractive than simply not receiving any rent, but whether the government is simply going to be in a position to contribute to that as well, I don't know. More recently announced has been a working group which has been established with the commercial rental sector to develop a code of practice. And the government specifically says that the code will encourage fair and transparent discussions between landlords and tenants over rental payments during the pandemic, provide guidance on rent arrears payments and the treatment of those that are subletting and suppliers. The intention is to publish it before the next quarterly rent date, and it is due to be a temporary measure, but the government has said it will consider making the code mandatory if necessary. So we'll have to wait and see what comes out of that, but I suspect that is intended to be in place of the other ideas that have been mooted. So I suspect the June quarter is going to be pretty awful, frankly, particularly in hospitality. Other businesses are perhaps seeing more signs of life and more signs of getting back to normal. So I mean, we're all actually sat in the office today, although we're some of the few in our firm. But it may be that the businesses that are hospitality, retail, leisure will start to get more back to normal. But retail, obviously that's due to, non-essential retail is due to reopen on the 15th. 9 days trading before the quarter day, I can't see that's going to make a huge amount of difference, but it might well mean that they are able to make proposals in terms of making payments, even if it's not the full quarter. Hospitality still won't be open, so I suspect June, at least to start off with, in terms of timely payment, will not be great. But we'll just have to wait and see what comes through in the next few weeks. I'm going to hand over to Ellie now, who has some advice for tenants.
As we've just talked about, we've got the Coronavirus Act, the regulations that are amending CRA, we've got the likely implementation of the Insolvency Bill. All of these are helpful to commercial tenants during this very difficult time. But tenants do have to bear in mind that the rent will have to be paid eventually. The landlords may be willing to either take temporary rent reductions or allow tenants to pay in monthly in arrears, but they will want their money eventually. The interim measures will be relaxed at some point, and landlords will once again be able to forfeit. They'll be able to issue winding up petitions, and so the best advice that we can give to tenants struggling to pay the rent is talk to your landlord. Open a dialogue. Landlords are not going to want to lose a tenant in the current situation. They're not going to want void properties, and therefore they're more likely to be amenable to rent deferrals, alternative payment schemes, moving to monthly instead of quarterly payments, things like that. Tenants can also look for other ways to make savings. For example, could you reduce your insurance premiums if you've got fewer staff working premises, if your premises are completely closed or they're not open to the public? That's a possibility. There are also business rates savings, business rates relief available for certain sectors, specifically including retail, hospitality and leisure, as well as certain grants available. I think Vicky mentioned a couple of those. But the overarching advice really is talk to your landlord. It's as simple as that. So Vicky's now going to see what landlords can do.
Thanks, Ellie. It will be no surprise to say that my overarching advice is, likewise, as Ellie has said, to talk to your tenants. There is no one-size-fits-all remedy depending on the type of tenant you've got and the nature of the business, the nature of the premises. And therefore, depending on what you want to do, it's always worth seeking advice on what your specific options may be in any given circumstance. But ultimately, you need to think long term. There is no point in ending up with a vast swathe of empty properties which are going to be extremely difficult to re-let at present. That's not going to help anybody, and it's just going to cut off the rental income. If you do want possession, consider whether any other breaches can be established, which Ellie briefly mentioned. You can still forfeit for other breaches, so unlawful subletting, repair obligations, that kind of thing. But again, think very carefully as to whether you're going to be in a position to re-let the property. You're then going to have the rates liability. There is no restriction on negotiating a surrender, so there's absolutely nothing wrong with doing that. But if you are thinking down those lines, again, maybe take some advice at an early stage, because as soon as you start talking about negotiating a surrender, you will waive your right to forfeit for any existing breaches. consider the other remedies in terms of rent recovery. Ellie's touched on commercial rent arrears recovery. You can still bring a claim through the court to seek a judgment for outstanding rent and consider enforcing that once the current restrictions have been lifted. Right now, although not for very much longer, it may be possible to go down the statutory demand / insolvency route. If the bill is delayed much longer, you never know, that might well actually achieve the result you want. But ultimately, I think the key is negotiation. Think about striking that balance, trying to get some income in, but also being really, really careful about how that is documented. You don't necessarily want to, you might be prepared to agree a deferral for the rent, but you don't necessarily want to inadvertently agree that that will just be a rent holiday and will be written off. So again, seeking advice on precisely how that is documented is quite important. So that's the end of our formal bit. I will hand over to Jane for some conclusions.
Thank you, Ellie and Vicky, for those comments. So yes, by way of conclusion, the clear message is for tenants who are struggling to pay their rent to talk to their landlord. Putting their head in the sand is going to help nobody and is likely to make a landlord more inclined to take whatever limited action is available to it. Our experience over the last quarter is that landlords have generally been very flexible and understanding of tenant situation, and they have recognised that the landlord and tenant relationship is hopefully a long relationship, and so they've been pretty tolerant of the situation. Not everybody, but we'd say the majority. But it does remain to be seen whether that same flexibility will apply to the June quarter, because of course this will be the second payment that landlords have not received, and landlords themselves may be struggling and need that money. So we'll have to see if things have got a little bit less flexible. So basically, it is very challenging for both landlord and tenant. Landlords are extremely restricted on what they can do, and we'll have to see if the provisions that have been made are extended beyond the 30th of June. If they're not, we're expecting to be quite busy. So we will see what happens going forward, but if any questions and issues arise, then we are standing by to deal with them. So as I said at the beginning, we now have an opportunity for you to ask questions. Gareth has asked about the code of conduct that the government are looking to put in place, and for the parties to look at negotiation. And he asks if we have any further detail. I have had a look at that. Vicky or Ellie, have you got any comments on that?
I haven't been able to get much further detail. And as to how enforceable it will be, all I've seen is that the government has said that if it isn't voluntarily complied with, they will consider making it mandatory. But at the moment, I think because they're still working on it, there isn't much more information available.
Yes, and I think, as Gareth mentioned, the key messages from it are for there to be transparency and for them to negotiate. But what I would say is that our experience of these sort of codes is that they're not, I would say, not generally followed at all, or very limited. So it's a nice idea, but at the end of the day, landlords and tenants have to look out for their own commercial situation. So I'm not absolutely convinced how much impact it will have, but we'll see. Then we've been asked if a tenant has recently committed an environmental breach, is this grounds for forfeiture when the bill comes into force? My understanding is that an environmental breach is not non-payment of rent, and therefore that would be a ground for forfeiture. And a section 146 notice, a sort of warning that forfeiture will follow, would need to be served first.
Yeah, that's the situation.
Yeah. Are we seeing any evidence of tenants seeking to negotiate COVID-19 clauses into existing leases as part of dealing with the current rental challenges? I expect that they are, but that's not, we don't deal with the drafting. So I'm sure our commercial property team would have comments on that. What I would say is I've seen lots of commentary and precedents flying around with such clauses. So the impression I've got is that they are fairly popular. How likely do we think it is that the relevant period of these regulations will be extended? Vicky, do you have any thoughts on that?
Personally, I think it's very likely, because it's only until the 30th of June at the moment, so falling just after the June quarter day. I can't see the government is suddenly going to want to see a massive increase in forfeiture at that point. So I suspect it will be extended, but it's very much wait and see what comes out.
Yeah, I agree. And another question is, what is the most appropriate way to document a move from quarterly to monthly payments?
I've dealt with this and I've done it by way of side letter. The main thing to do is make sure it's not an actual variation of the lease, make sure it's clear that it's only a temporary arrangement.
Yeah.
So a side letter is generally fine.
Yeah, and we have drafted quite a few of those, and as comment was made earlier, it is actually very important to document these amendments so that when you want to get back to the regularity of payments as before, that you haven't sort of affected the position, and you're right to do that. Well, this is an interesting question. What long-lasting changes do we think will arise from this episode? Possibly monthly payments. Do we think that will become the norm, or will we be stuck with the quarterly? Personally, I think that I can't really think that there will be any long-lasting changes, in the sense that many leases that are in place are probably going to extend well beyond the current pandemic, or let's hope so. And so those still provide, for example, for quarterly payments and still have the existing provisions. But I think that the knock-on effect of the pandemic and the rent arrears that are building up will have a lasting impact and repercussions for landlords and tenants for quite some time to come. But that is an interesting question. I'm going to give that some more thought after this. Alistair has asked about bailiffs. Are we aware of any bailiffs who are actually prepared to enter buildings at the moment in this pandemic?
I'm aware of a couple of companies.
Yeah?
Yes.
So the social distancing doesn't seem to be holding them back.
I think they're still taking precautions. Obviously, they need to make sure that their offices are safe, but they are certainly still open for business, subject to taking precautions.
Thank you. Another question is, what if a tenant is in rent arrears, including insurance rent, from September 2019, and the landlord's been trying to negotiate, but hasn't got anywhere? Will the landlord still be able to enforce in relation to those arrears?
They've got all the other methods of enforcement, so they can, at the moment, statutory demands are still permitted, winding up petitions are still admitted, as are court proceedings. And I think, Vicky, you were saying something yesterday that's quite interesting about some of your landlord clients who have been choosing to issue proceedings even though they might not be able to enforce it.
Yeah, because ultimately they will be able to enforce it in the future. But I would say if you've got a tenant that is in arrears since September 2019, then the insolvency bill is absolutely not aimed at that situation. And actually, you would still be able to issue your winding up petition if that's the route you wanted to go down. And it is likely, although you wouldn't be able to advertise it and do it in the normal timescale, at that first hearing, when you show that there's been 6 months worth of arrears prior to the pandemic, it is likely that the court will then authorise the winding up to proceed.
Okay. Alistair Frew has just let us know that COVID-19 clauses are now being asked for. So yes, as I suspected, but thank you for that, Alistair. Another question, they're interested to know our thoughts on the landlord's potential use of rent deposits. That's interesting. I mean, I would have thought that's not expressly covered, so far as I'm aware, in the regulations. So that the rent deposit could be used.
Yeah, I see no issue with that, apart from getting it topped back up. Once you've used it, it's gone. And although there would then be requirements that would oblige a tenant to top it up, it's physical enforcement of that may be tricky at the moment.
Yes, absolutely. Can temporary waivers or alterations be agreed via email, or do you need a physical letter?
I can't see any problem with it being by email. No,
I can't. No, and there's been so many amendments and sort of agreed ways forward. Just for example, even signing leases and wills, you know, the way people are managing to achieve things without without breaching social distancing has been all very imaginative and quite clever. So yes, email, we think that would be fine. There's a comment here that it seems unfair to fix nil increase rent reviews or low rents at renewal in the middle of this whole pandemic if rents are going to bounce back in due course. I think that's a really really interesting point, but presumably when the rent review or new rent, if it's a renewal, is being assessed, a longer term view would be taken rather than just looking at the current position. Although I do get your point, obviously evaluation has to be on a certain date. So yeah, that is going to be very interesting. Any thoughts on that, Ellie and Vicky?
Only that I've seen clients arguing exactly that it should be nil increase. But I also wonder whether the argument that rents are going to bounce back, I don't know. That, I mean, that very much remains to be seen, because once we get through all of this, particularly with retail, I imagine there may well be a big hit still in terms of the rents moving forward, because of the number of retail insolvencies and administrations and that kind of thing, and the number of empty units that we may see. But if you, I suppose as landlord, if you are facing that type of argument, your option is always, particularly on a renewal, your option is always to let it play out, because of course the rent would be determined at the date of any hearing determining it in the lease renewal process, which will be months and months down the line. Yeah. And so in some ways it might be better from that point of view to drag things out in terms of the renewal, and argue it out at that time and see if the rents have then bounced back, you will be in a much better position. And the likelihood is, if that's what's happening, then you are going to reach a settlement on that basis anyway before the final hearing. So it's not necessarily right now that you're looking at.
Yeah, and I think that's a good point and a good strategical tip, really. Dragging things out will probably help. Although going back to the point about the long-term effect of this pandemic, and it would be really nice to have a sort of full discussion on this rather than the messaging. But I think that it surely will have an impact on rents in terms of reducing them because of the amount of empty properties there are going to be. So next question is, a tenant's about to go into administration. They could pay rent, but are saying for COVID reasons they won't. A pre-pack is anticipated. What protection does the administrator have? And would the buyer of the assets have any rights of protection regarding occupying the property? Well, an administrator does have protection, and the permission of the court is required anyway to take any enforcement action, and that was the case pre-COVID. And the administrator, I think, will be able to rely on the same protection as the tenant. And buyer of the assets, then they are going to be, if they haven't got a formal assignment with the license of the landlord, then they are going to still be open to potential forfeiture, although landlords might be only just too delighted to have a tenant. So we are at time. It's just gone 9:30, and I can see that there are some other questions we haven't got to. Very happy for anyone who's got a question that we haven't got to, just to pick up the phone and be delighted to have a chat with you. Or if you think of a question that you haven't asked later, then please do give us a call. And that's absolutely how we operate. If there is at any time something that you'd like to run by any of us, just on an informal, the phone, the clock doesn't start ticking, you'll be glad to know in those circumstances. So please feel free to give us a call, and we would be really pleased to hear from you. So thank you very much indeed for joining us this morning. I'd like to thank Ellie and Vicky for their presentations. I'd like to thank Angela and Colin, who are supporting us technically in the background. Really appreciated. And just to say, take care everybody, and enjoy the rest of your day. Thank you.